Welcome. I'm Michael Graham with InsideSources. Thank you so much for joining us here at the National Press Club for this event about the current state of antitrust. We have a terrific panel of guests to present to you, courtesy of our friends at ACI, but we have a very special message for everyone from U.S. Senator Rand Paul.
Thanks to the American Consumer Institute for the invitation. I'm sorry I couldn't be with you in person today. While it is easy to get caught up in the complexities of the modern antitrust debate, it's important to understand what is really at stake when it comes to the recent actions by the FTC and the DOJ. We're not talking about a few overly zealous bureaucrats experimenting with novel, if somewhat aggressive, legal theories that test the bounds of American competition policy. We're talking about a coordinated attack on the very foundation of the United States' approach to antitrust law. The consumer welfare standard, the principle that the antitrust laws exist to protect consumers, not competitors, has been a cornerstone of American economic policy for decades. It's a simple idea. Antitrust laws exist to keep prices low, encourage innovation, and protect competition within the market. But now that the principle is under attack, and with it, the very foundation of the U.S. policy to antitrust, we have to stand up and say something. The bureaucrats at the FTC and DOJ are waging a dangerous war aimed at dismantling the consumer welfare standard, and the consequences will ripple through our economy. Their overreach isn't just a misguided attempt to meddle in the marketplace, it's a direct threat to American consumers and our economic system writ large. If they are allowed to continue down this path, the results will be clear. Consumers will see higher prices, fewer choices, and a stagnant economy. The market is already feeling the squeeze. Companies are bleeding hundreds of millions of dollars, layoffs are piling up, and consumers are being left in the dust. Look at the crusade against companies like Amazon, Facebook, Google, Nvidia, and Twitter. We're told this is about reining in big tech, but what will these proposals really do? Protect the status quo, cementing the dominance of the very companies they claim to be challenging. If you hamstring innovation and punish success, what's left? Consumers lose out on better services, lower prices, and technological advancements that have improved our lives. This isn't the path to a thriving competitive market. This is the path to economic decline. The Democrats are even dragging out the dusty relic known as the Robinson-Patman Act, a Great Depression-era law designed for an economy that no longer exists. The revival of this outdated law threatens to undermine decades of progress, raising prices and discouraging innovation. And with the DOJ's demonstrated willingness to block mergers, even when those mergers with lower prices, antitrust law is being weaponized against the very people it's supposed to protect. This radical agenda is not just hurting business, it's devastating consumers, stifling innovation, and damaging America's global competitiveness all the way. But there is an even darker side to this antitrust crusade. Democrat candidates have already expressed a willingness to weaponize the FTC to impose price controls in order to combat so-called price gouging. Yet history shows us that price controls don't work. Even more, they actively harm. They lead to shortages, inflation, and a major reduction in consumer choice. Yet that's exactly the path we're headed down if things do not turn around. This isn't just a difference in economic policy, it's an ideological battle for the very heart of the American economic system. Some in Congress aren't satisfied with the successes of the free market. They want to replace competition with government control. It's ironic. They rail against the curse of bigness in the private sector, but when it comes to big government, the bigger the better. They'll never admit it, but their real aim isn't protecting consumers, it's picking winners and losers, punishing businesses they don't like, and deflecting blame from the administration's own inflationary policies. Let's be clear. When government bureaucrats decide who wins and who loses in the marketplace, American businesses suffer and consumers lose out. When companies are penalized for creating better products and services for their customers, American consumers will suffer. And when antitrust law becomes a tool to advance certain political agenda, American liberty suffers. This isn't just about dollars and cents, it's about freedom, the freedom to compete, to innovate, and to succeed. That's why I've proposed legislation to repeal the Robinson-Patman Act. It's an old relic that has no place in our modern economy and ought to be repealed immediately. If we're serious about lowering prices, tackling inflation, and protecting consumers, the answer is simply to get government out of the way. Let the free market do what it does best. empower consumers, foster competition, and give every American the opportunity to succeed. Thank you.
And thank you to Senator Rand Paul for that. And I think he set up the conversation in a really valuable way for us, which is it's not just about outcomes for consumers, it's also about freedom. And I think there's a real question, is it? Or is it really about outcomes for consumers at the point of antitrust law? And of course, there are a million other conversations to have, but when it's the American Consumer Institute, you want to focus on the consumers. And so I want to present our panel today. Neil Chilson of the Abundance Institute, where he's the head of AI policy. Tirza Duran with the ACI, she's the Vice President of Policy and Research. And former Federal Trade Commissioner General Counsel Alden Abbott of the Mercatus Center, one of my favorite places in the world. They do outstanding work. And why don't we start with you, Mr. Alden?
Well, thank you. Thank you so much. And I can't say it better than Senator Paul, but I'll try just to add a little bit of decoration to his comments. In 1890, the Sherman Antitrust Act launched the world's first comprehensive system of limits on anti-competitive business conduct. By the mid-1970s, after 80 plus years of common law development, the Supreme Court started to stress the importance of economics and modern economics in trying to put a structure on the Sherman Act so that only harm to consumers would be targeted. Indeed, the Supreme Court in 1979 said that a consumer welfare standard is a standard of antitrust. They said, we understand antitrust laws have developed and been interpreted as being, quote, a consumer welfare prescription, close quote. Since that time and up until the current administration, basically there had been a bipartisan consensus developing that consumer welfare was the key standard of antitrust enforcement. Interestingly, and perhaps ironically, President Biden himself in 2021 said the purpose of antitrust is to promote, quote, the best allocation of our economic resources, the lowest prices, the highest quality, and the greatest material progress, close quote. Sort of sounds like what Senator Paul said, except as we'll see, what happened in practice is not quite that. Now, a radical change in the approach to antitrust began in 2016. And before mentioning it, I should mention that this is not just something modern, consumer welfare standard. Adam Smith, the father of modern economics and the Wealth of Nations, said, quote, consumption is the sole end and purpose of all production, and the interests of the producer ought to be attended to only so far as it may be necessary for promoting that of the consumer welfare standard. Herbert Hovenkamp, the leading current antitrust treatise writer, has written that, again, the goal of the antitrust laws should be consumer welfare, maximum output consistent with sustainable competition, promote in quantity, quality, and improvements in innovation, all consumer welfare. So what happened? In 2016, the final year of the Obama administration, Attorney General Lynch said, well, we're going to have to start looking at economic justice, not just consumer welfare and antitrust. There were a study by the Council of Economic Advisors in 2016, a study which, by the way, I think was debunked by a 2020 study by the Council of Economic Advisors, said industry concentration, a number of firms in markets has risen, competition has gone down, antitrust hasn't worked well. Senator Elizabeth Warren in 2017 said, in antitrust, we now need a better deal initiative, echoing themes already set forth the year before about needing to supposedly strengthen antitrust. Open Markets Institute, a progressive Democratic-aligned organization, and liberal media started using similar themes to mount a radical attack on U.S. antitrust in 2017. A House of Representatives, now under Democratic majority, did a committee report largely authored by Lena Khan, a young Yale Law School graduate, saying that antitrust really had to be revamped, and including legislation and massive change, much more aggressive enforcement. Now, the Biden-Harris administration, Lena Khan at the FTC, and Jonathan Cantor at the Justice Department Antitrust Division have tried to really launch a revolution of sorts, ignoring the last 4 decades of antitrust. They've returned to long-credited, discredited antitrust rules for business conduct, including structural presumptions in mergers, that is, a higher concentration. If there are fewer firms and more big firms, it's bad. You should presume a merger is illegal. That is inconsistent with economic learning. And all sorts of prohibitions they thought should be applied to digital platforms. And indeed, there were attempts from about 2021 to 23 to pass legislation. I think Senator Klobuchar, a few other senators, that would have restricted mergers and the contracts that entered into it by Facebook, Google, Amazon, and so forth, basically saying they have to open up their platforms to competitors. They can't make acquisitions. Any platform that's above a certain size can't acquire firms. All sorts of stuff of that sort. Legislation did not pass, but the agencies kept pushing along. Senator Paul already mentioned the Robinson-Patman Act, which really would raise prices. It basically makes it hard for big firms to request discounts, big distributors, and it discourages discounting by suppliers. And indeed, it's been applied in the past and was roundly criticized on a bipartisan basis, including a 2016 bipartisan congressionally issued report that said the law should be repealed. So what have the agencies done? They've made lots of misleading reports about the history of recent decades, saying competition has gone down, saying that the mergers don't do any good, and so on and so forth. So what has happened? There's been a real, even though the agencies have not had a great deal of success in bringing lawsuits, and indeed they haven't emphasized some of the more far-out ideas in actual legal filings in court. Nevertheless, certainly one hears, if you talk to people involved in merger practice and antitrust practice, a lot of uncertainty, lots of deals that would have improved efficiency and innovation in the American economy getting dropped. A reluctance to enter into sort of exclusive contracts, all sorts of arrangements that would have not raised any eyebrows just a few years ago. And really, not only this, the Biden administration said, well, and certainly the FTC in particular, you need to look at labor rights, civil rights, promotion of equity, and protecting the environment should also be key aspects of antitrust. And indeed, there's a supermarket merger being looked at right now where it's being argued that protecting union rights in 2 big companies is the goal of antitrust. There's no case law that supports that notion. I don't think it will succeed, but in general, again, there seems to be an attempt to make it a law that applies to everything in the economy, sort of an one economy approach. Antitrust solves all problems. That's inconsistent with the history of the law. It's been really applied to specific kinds of business conduct that distort competition. But again, this discourages transactions. Firms think, well, we may eventually win, get cases dismissed, but we don't want to have to, in our SEC filings, talk about all of these legal risks. And we don't want to bear all the costs associated with potential litigation. So where are we now? The Senate, some have called this, a couple of colleagues of mine, an antitrust immunity. And so the basic points here are, does this make any economic sense? Well, Europe is often praised by current antitrust enforcers, saying we have to be just like the Europeans, who are much more interventionist, or maybe even go beyond where they are. Well, up to now, Europe has not produced any great innovative platforms. Their economic growth and per capita GDP has slipped steadily over the last 20, 25 years of interventionism against the U.S. And of course, countries that have authoritarian regimes have never had a great deal of economic growth. But the idea of a more centrally controlled, prohibitive antitrust that focuses on risk and prohibition makes no economic sense. And again, economic history doesn't suggest it would succeed. Now, I would argue, and I think many scholars that would say that the professional standing of the Federal Trade Commission, Justice Department, have suffered because of this overly aggressive approach. And also, as I've suggested, a hostility to transactions and to mergers and to bringing all these monopolization cases, whether they succeed or not, and even if the filings in court aren't radical, these sorts of things are discouraged firms from innovating. Just as from 1969 to 1982, a monopolization case by the Justice Department against IBM turned it from a major innovator into basically a firm that was not part of the later computer revolution and then the internet revolution. Still a good company, but clearly was harmed. That should be a cautionary tale, but we'll see what happens. So my takeaway is straightforward. To prevent additional damage to the U.S. and global economies, which could be severe, threatening the continued innovation so essential to our future economic growth and a tolerably peaceful domestic and international order, the U.S. agencies should return to the pre-Biden consumer welfare enforcement approach grounded in sound economics. They should also advocate it on the international scene, saying, instead of saying, we were wrong, you guys are right, saying this is an approach that's going to promote economic growth around the world. Because we're in a global economy, if we exceed and agree to bad policies around the world, that's going to hurt our innovative firms, both in the U.S. and overseas. I'll leave it at that. Thank you very much.
Tirza, why don't you introduce yourself and share your comments?
Hi, I'm Tirza Duran from the American Consumer Institute. Thanks again for everyone for being here. One of the things that I really want to focus on today is when we're talking about the current debates in antitrust, these debates aren't new. They're kind of rehashing old conversations that we've already had. I think there's a benefit to this because we can hopefully, and that's something I try to do in my work, is hopefully learn from the past mistakes, understand how we went from a more comprehensive antitrust environment to one that's more focused on consumer welfare, and hopefully avoid some of the past mistakes. And so when I'm talking about past mistakes, I see this happening in two main camps, and it's kind of a broad brush, but I think it's useful for communication purposes. You have the more neo-Brandesian camp, and then you have more of the consumer welfare standard camp. And one of the things that you have with the neo-Brandesian model is, as Alden already said, they take a very holistic approach to antitrust. They include kind of their ideal society, their ideal economy, and also their ideal political systems. And so while this kind of broad approach might seem really great in theory, the downside is that, or I guess the kind of ironic side, is that when it comes to enforcement, it's actually very rigid and very specific. And we see a lot of really negative cases coming out of that. We have Vaughn's Grocery, which is really heavily discussed, and Brown Shoe. And both of those cases blocked mergers that would have resulted in a relevant market concentration of under 10%. And so we can see it kind of being very overly aggressive. On the flip side, you have the consumer welfare standard. And while that takes a very narrow approach to harms, it's actually quite flexible when it comes to enforcement. One of the things, again, that Alden said, it's really rooted in economic analysis. And so one of the critiques that the neo-Brandesians have is that current antitrust law isn't able to adapt to the growing, changing economy or handle new dynamic companies like Amazon, or Amazon's a big one, but all the tech companies. I had a brain fart for a moment. And I would actually argue that the inverse is true, because you have something that's very focused on a very specific harm, and because you have something that's really rooted in economic analysis. As markets change, as economic knowledge grows, and we have better research, we can actually apply these very specific laws in new and innovative ways moving forward. And so those are kind of my main spiels about what's happening, and we can get into more specifics later if people would like.
Neil, also introduce yourself and begin, but first I got a note that Tirza's playing hurt. She's got some health issues, and she showed up anyway, and so we're glad that she's here.
Great, that's awesome. My name is Neil Chilson. I am the head of AI policy at the Abundance Institute, which is a relatively new mission-driven think tank that's focused on creating an environment for emerging technologies, both in the cultural space and the policy space, that allow them to prosper and grow. And we believe antitrust is a key part of that environment, and getting it right really matters. And it matters because new technologies promise to deliver abundance for all of us, for consumers. Widespread human abundance has been, the primary driver of that has been technological change. And antitrust obviously plays a big role in how companies can have the incentives to create that innovation and to deliver it to consumers in ways that solve problems that they face. So I'll touch on three things that will build on all the comments that have been said today, and hopefully add a little bit of color, although probably not a ton of knowledge. First, if we step back and think about why there is this movement for antitrust reform now, I think it's a very interesting question. And when I look at it, what I see is a group of individuals who have an aggressive vision for how they want to change the world, and there are limits. And there are limits to what they have been able to accomplish through the legislative process. And so when you look around for big, powerful policy tools that are very general and that could change the entire economy, antitrust is one of those. Antitrust is a very broad law, a very broad body of law. It applies to economic activity across the economy. And it has a past that's complicated in the law. Early on, it was very hard for the courts to figure out exactly what Congress meant when they said, no combinations in restraint of trade, for example, because that language has a bunch of different possible effects. So the way I like to think about this is that competition always hurts competitors, right? Anti-competitive conduct also hurts competitors. And so courts have to figure out which one of those they're looking at. Is it competition or is it anti-competitive conduct? And you could think of a lot of different ways that you might measure that effect. And we've heard a lot of them being resurfaced now. But what the court settled on eventually was that we need to go with one metric. If we're trying to trade off consumer welfare versus the environment versus small business making money versus labor or equity, courts are going to be able to come up with any decision that they want. When they're faced with a fact pattern, they're going to be able to say, well, yeah, this one's bad for consumers, but it's good for the environment, and it's bad for labor, but it's good for small business, so I'm going to decide this way. That's not a system in which we have rule of law. That's a system in which business is constantly worrying that if they get on the wrong side of a political fight, that there will be a big antitrust case against them. And this is how antitrust had been used in the past. One of my favorite stories is that Richard Nixon actually threatened some of the broadcasters with antitrust action if they didn't cover his daughter's wedding. And that worked. They covered his daughter's wedding in primetime. So that's maybe a playful type of manipulation, but you can imagine things getting a lot worse, especially in a political environment where certain companies are heavily politically disfavored. So the big stick of antitrust, I think, has made it and its flexibility, at least historically, has made it appealing as a way to try to reshape the entire economy. You hear often that this is about big tech, but the neo-Brandeisians and people who want to reform antitrust, it's not really about big tech to them. And if you talk to them, they'll honestly say, like, they want to shape all big companies, and you'll see that a little bit on pharma. They tend to pick the politically unpopular targets right now because that works for them. But overall, they want to reshape antitrust in a way that allows a progressive vision of the economy that is very different from, the historical U.S. approach to the economy. And fundamentally, when you think about it, it's incredibly anti-democratic. We're saying that rather than having to work through the compromise process in the legislature to get new types of economic regulation passed, that we're going to shortcut all of that and we're going to create legal precedent through decisions made in courts or sometimes made just in settlements from FTC commissioners or with DOJ enforcement that will reshape the economy. That's fundamentally anti-democratic, and I think we should call them out on that. So it's not really about big tech. It's a big stick. If you go to lots of different factors, you're not going to get really good rule of law. But ultimately, because I'm a technologist and that's my background, I do want to talk just a little bit about the effect that it would have on innovation and the effect that that would have on consumers. In particular, in the AI space right now, we're having a lot of interesting discussions. It's been crazy to me, actually. ChatGPT came out 2 years ago, about. Almost immediately, when that consumer-facing product, which is one of the fastest-growing consumer-facing products ever, was adopted, antitrust enforcers came out and said, hey, this might be a competition problem. That was their first reaction to this technology. And if you look at the FTC's blog post, their first blog post on antitrust and AI is entirely a list of potential competition problems with AI or in the AI space. Whereas I look at this technology and I see the great potential it has to create competition, not just theoretically. There are hundreds of new companies in this space now that did not exist. There is a company called OpenAI that nobody really had heard of 3 or 4 years ago and is now a major tech company. And there's a bunch of other ones like that. And so I think it just shows the mindset of these antitrust enforcers is one that's focused not on what's good for consumers, but is on where they have potential threats to their power and where they might be able to exercise that in a way that's politically feasible to change the world to look like they want it. And so we could talk a lot more about AI. Well, I could talk a lot more about AI and antitrust, but I'd really like to move on to questions and hear from you all about this because I do think that this area is so interesting and there's so much to dig into.
Thank you very much. And how about a round of applause for the panelists? So we're going to take some questions in the room. Also, if you're watching on the stream, there's a little bubble and you click on it and you can send a direct chat to questions in case you're not sure where to send the questions to, and we'll take your questions and share them. But I'm going to take the moderator's opportunity to start with Professor Alden and ask, or Doctor, or Mr. Smart Guy, Alden.
No, just call me Alden.
I hate asking lawyers questions. It's always dangerous, particularly about the law. But my understanding is that the current approach on antitrust has had some really bad luck in the courts. What is the obstacle to their attempt to reshape this not consumer-centric AI? Is there a legal doctrine that we should cling to, that supporters of traditional antitrust should cling to? And what is stopping them? What's the status of the law?
Well, the status of the law really is the Supreme Court over the last few decades has developed a number of standards that make it hard to win cases without good economic and factual basis. To win a monopolization case, you have to define a market, and that's where you actually have market power. You're like control a huge amount of the market, and you have to show that your contracts or whatever you've been doing is not competition on the merits. If it's just competition that actions, for instance, by let's say Amazon that improves your search engine and improves your software, if it's actions that actually improves consumers, even if your competitors can't keep up, a monopolization case would fail. Mergers have become, again, you have the courts, as a practical matter, have not, Supreme Court hasn't looked at mergers in decades, But the appeals courts are very careful in looking at mergers. Have you shown actual likely harm to consumers? And the Supreme Court has gotten rid of lots of old standards that said something is automatically illegal. They've said most things are under antitrust rule of reason. You have to show harm, likely harm to consumers. And some of these cases that have been brought, for example, by the FTC, I think they sort of failed in showing that there's likely consumer harm, or they've tried to define markets and this is a marketplace that's harmed when it doesn't hold up to the facts, and they haven't had a lot of success. So I think part of the frustration, they've won a couple of strange cases, but without getting into details, I think it's the Supreme Court precedent that and the Court of Appeals, who have applied a consumer welfare standard consistent with guidance by the Supreme Court, that says it's very hard to win a predatory pricing case. It's difficult to win a monopolization case. It's always focused on harm, economic harm, harm to consumers, harm to innovation. That's not necessarily easy to prove, because a lot of these cases, you're not showing harm. You're showing that some competitors aren't doing as well. And now they're trying, in some of their big platform cases, well, you should help your competitors. If some of your competitors don't have a big enough market share, your Google, why haven't you helped your competitors more? Well, that's not what the case precedents say, unless it's likely to harm consumers. So that's frustrating, I think, the agencies, and maybe their solution will be to pack the Supreme Court, put a bunch of radicals on the lower courts too. So that's a political issue. Who's going to win some elections? We'll see what happens.
For all the panelists, what about the argument that just some of these companies are just too darn big, gosh darn it, and you just shouldn't be big, and there may not be anything bad happening? I had this conversation last night in Washington, D.C. with some people. They're very angry. I don't like the way Amazon does business, and therefore they're too big. Is there any legitimacy in that? Does that go back to the Teddy Roosevelt era of how trust busting should work? And what is your answer when you hear that complaint?
So when I hear that complaint, there's a bunch of different reactions I have. The first is that compared to what? And also when people say they're all too big, you look at them and I see them competing with each other quite a lot. And so they're all competing with each other often, not on every front, but Amazon competes with Target and Walmart, both of which have very large online sales platforms that actually in some ways copy what Amazon is doing. Google and Facebook compete on online marketing, et cetera, et cetera. And so that's part of it. The other thing I would say is that technology has changed how business works in many ways in a hugely beneficial way. So it has really created what are called returns to scale. So you can now run an organization. These companies, honestly, if you look at them historically, they're not that large employment-wise. Right. They are large in what they can deliver for consumers. And so it's become much more efficient to deliver something that's low cost at a large size. Now there's lots of opportunities for disruption in this space too. I think AI is going to allow smaller companies to punch way above their weight, because a lot of the organizational paperwork that you kind of need a big company to do is going to become easier. And so I do think that there are technological changes that might push us in a different direction. But I think when people look at these big companies and they say, I get all my stuff from this company and therefore I'm worried about it, what I ask them is like, would you rather be getting more expensive stuff from smaller companies? You are very welcome to find those companies and purchase from them. I'm sure they would be happy. But most consumers see these as hugely beneficial. These companies are still very popular.
Yeah, one of the things that I think, I agree, big compared to what, who kind of sets that standard. But the other thing that I think is really important to talk about is one of the key parts of kind of the more neo-Brandeisian movements is what they refer to.
Could you just define that real quick for those of us who vaguely remember who Brandeis was?
So yes, well, I'm not going to do like a hard definition, but earlier I kind of mentioned that when you have the two camps of debates that we're talking about within antitrust, you have more of those who are focused on the consumer welfare standard, and then you have those that see a more holistic approach to antitrust. And by holistic, I mean they see it as a tool to alleviate a wide array of what they perceive as kind of social harms. Right. So that's the term I'm using to describe this more broad approach to antitrust.
Because of Justice Brandeis.
Yes, it's named after a specific, yeah. And so the question was big as bad. Okay, so I think one of the other things that's really important to talk about is this kind of movement. One of the social harms that they really focus on is kind of more what they refer to as democratization of the economy. I think it's a little bit ironic. Well, I think it's a lot of bit ironic that when you're talking about how these companies got too big, I'm like, that is actually the results of your democratization of the economy. Like Neil pointed out, if you want to go shop for small businesses, you can do that. Ironically, there's also Etsy, which kind of is a big platform that allows you to bring all these small businesses to yourself. But I think the other thing that's really important is when we're talking about these conversations and we're talking about size, is that determining anti-competitive harm through economics is challenging. And Alden already mentioned that a little bit. And so what we see is oftentimes a streamlined / lazy, depends on how you look at it, approach to establishing what anti-competitive harms are. And so one of the ways you can do that is you can look at the size of a company, you can look at concentrations of an industry, and then you can use that as a proxy for the competition in that marketplace, but also for the market power exhibited in that marketplace. Unfortunately, the economic research right now isn't really clear on the fact that there's very clear relationships. It's kind of sometimes yes, sometimes no. It doesn't really mean what you think it means. And so when we're talking solely about size, I think it's really important to go back to the economic research and realize if we're actually talking about known harms to society and consumers.
Okay, I've got one more question, then I'm going to take questions from the floor here and on the phone, and it's about technology. You mentioned it. Quick trivia question: what percentage of iPad users voted for Barack Obama in 2008? Trick question. There were no iPads yet in 2008. In 2012, the iPad was one of the tools the Obama campaign used for their amazing voter turnout model that changed the electorate because they're able to reach low motivation, non-traditional voters with this tech just in 4 years. And so my question, and we'll start with you, Mr. Abbott, is it possible for regulators to be able to anticipate the changes in technology in such a manner that they can say, in an era where you can go from this product didn't exist to everybody's using it in a single presidential term, in order to bring about some sort of fairness or to advantage smaller businesses that you may want to thrive for some ecumenical purpose? Is it possible?
No, because I think as Yogi Berra said something along the line, the future is the problem in the future is it's hard to predict. There's something, I mean, if you look in 1995 when Congress passed new legislation on telecommunications, it didn't mention the internet. Nobody had any idea about how fast that would develop commercially. Nobody dreamt of, I think I was reading recently, 1983, in modern terms, it was $6,500 or more to buy the smallest Apple personal computer at that time, which had maybe one thousandth the computing power or less of any smartphone we have now. People cannot predict these things. Economists, good economists, have already known that. Friedrich Hayek, Nobel Prize winner, talked about information in the economy. It's developed two markets. Regulators can't predict that. If they were, they'd all leave regulation, become rich, for one thing. But it's also referred to the pretense of knowledge. That government experts like to claim they're going to solve a problem, but they're looking at yesterday's technology, and nobody can predict. And particularly, Congress can't predict it, so you can go after bad activities, fraud, violence, things of that sort. You can go after, but don't pretend to set up a regulation. The only thing you do by setting up a regulation because of potential problems you don't know is to slow innovation, to slow down future medical cures, to slow down new conveniences. Think, if you hadn't had Amazon and platforms like it, many more people would have not been fed well during the pandemic. It solved all sorts of problems. But if you've got a government regulator overseeing what a platform can offer, that might never become possible.
Neil?
This is the topic I spend a lot of time thinking about. I think generally there's a couple things that come to mind. First, the seen and unseen effect that you're talking about on innovation. One of the big challenges is that we often don't know, once a regulatory regime is put into place, it can be hard to see what we're missing. And that's why I think an effects-driven approach to solving problems is really important. We should focus on harms and then deal with those harms as they come up. Harms do not change fast, right? Financial harms, physical harm, maybe even if you want to get esoteric, like you could talk about emotional harms, but like us as humans, we don't change that quickly compared to technology, and the harms that we feel and that we experience and that we're trying to avoid don't change that quickly either. So they are much more on the time scale of regulation and legislation. And so if we focus on harms, I think we do better off. And that's one of the advantages of antitrust in some ways, done right, is that it can deal with harms if it's focused on harms, and it does it case by case, rather than having to have some big thematic approach to all technology and how you would regulate it. You can focus on, well, does this one harm consumers or not? Or is this particular business practice harming consumers or not? That is a relatively timeless principle, and I think it works pretty well. And we should, if we can focus on harms, I think we can manage the issues that come up with technology.
Do you have a question here? Yes, sir.
How do you prevent people from, or people with an agenda from saying, hey, this is a harm, this needs to be fixed, when it turns out there isn't one?
So it's a really good question. I think on the antitrust side, we tend to be very focused on economic harms, and so that does narrow the window quite a lot. Although, as we've been hearing, there are people who would like to broaden that window to deal with a lot of different types of harms. They still tend to try to phrase it in the economic frame because antitrust is about competition, and competition is about making, in a commercial environment, making money. On the consumer protection side, which I spent a lot of time working on at the FTC, there's a broader range of the types of harms that the commission might look at. And I would say, just as a first principle, if Congress decides something is a harm, that's a good first step, right? Like, you should have to convince Congress that something is a harm. That's building a sort of broad consensus across the political community. If Congress has not specified something as a harm, I think agencies should be very careful about incorporating that into a sort of consumer protection framework. And so, I have my own personal set of things that I think are harms and that are judiciable and that ones that aren't. But I think people should have to convince Congress that something is a harm before agencies start protecting consumers from it.
Right, and I think this is why, like the FTC, for instance, used to spend a great deal of its time on going after fraud, including internet fraud, statements that are false, and that the reasonable, and I said the reasonable consumers, something that reasonable buyers could be tricked into expending all the money on things that don't exist or bad products, often fly-by-night operators, and trying to come up with techniques to prevent that sort of stuff. Fraud is something that's been understood as harmful for well over a century, and much longer than that as a tort law, common law. There are things of that sort. Now the FTC is trying to even go beyond sort of traditional areas and talk about unfairness. But again, I agree with Neil. I think the focus should be really on harm to consumers. Now, has Congress acted? Congress passed a law dealing with children's online advertising protection. That small children, they say, could be harmed by exposure to certain ads. FTC was given a role there. Again, you have to make sure you apply it right. But if Congress, as Neil said, if Congress thinks there's a harm and there's a really vulnerable group, that's something to focus on. Very different than going after a big company because consumers like its products too much, and it's grown bigger and its prices have gone lower. Think of Amazon. Where's the harm to consumers there?
I think maybe this isn't new information, but it'll be pulled together in a slightly different way. I agree with Neil. If you can convince Congress of anything, then you're probably on pretty decent footing right there. But then I think there's also an issue where you have new technology and the kind of initial reaction is how will this create new harms? More often than not, and I've seen this a lot with AI conversations, is the harms are already established harms in law. And so when we're talking about protecting consumers, oftentimes we can look to existing laws, and maybe my whole suggestion is add and AI too. If AI does this, that's also bad. And so I think we have a very comprehensive framework for harms in society, and especially with new technology, looking at ways to incorporate it into that.
Alden Abbott, you're right, because fraud's a problem. When I was a kid, I ordered those X-ray specs from the comic book.
Yeah.
They did not work. I just want you to know. Yes, you have a question?
Yeah, I think there was a great notion of, competition and too big compared to what? And you talked about Europe, yay, and the lack of innovation there. And so happy that, we did get the internet right. We are hopefully dominating the new century. But what about China? And the fact that there is a global competition right now. And it seems as if China, is having big companies spring up. They are sending these companies out to dominate the world economically, conquer. Yet, again, the conversation comes back to us, wanting to load the gun and shoot at ourselves here. These are important companies. You buy an iPhone, $3 goes to China. The rest is going to a bank in California. So is that worth noting that we are in a global competition, and again, we are disadvantaging ourselves because there is such a looming, again, I'm from the State Department world, foreign policy, global competition. Does that enter into the equation?
And one of our journalists on the stream asked almost the same question. What happens to U.S. innovation if the neo-Brandeisian model continues? Do we fall behind China? So can we start with China and go from there?
Well, I think certainly could fall behind. I mean, China, it's interesting. They have invested, there's some inefficiencies, but they invested huge amounts of government R&D, huge amounts with a hope of dominating certain industries, including nanotechnology. They're very focused on AI. They also have a number of applied laws aggressively, they've been engaged in theft of patents. We haven't talked about patents, but protecting our intellectual property, which creates incentives to innovate, is important. This administration has also attacked intellectual property protection. And that really is also played to China's advantage, because if China wants to innovate, it makes it easier for them to steal our original work and to try and use their standards. And by the way, they don't use the same legal standards. They try basically not to pay less to our innovators or get the stuff free, while at the same time we're saying, well, we're worried some of our innovators are making too much on patent licensing. FTC brought a case against Qualcomm, one of our greatest innovators. So I think you also need new thinking. Why are you doing this? Are you just going after a company before it's big? But it's quite right. In global competition, China has made no bones. You look at their plans about their interests. And if you want us to become competitive internationally on AI, and which is going to be so important in all sorts of industries, regulate away or pass if you want to kill that. Or as the FTC and DOJ entered into a statement with European regulators about, well, here are all the risks to AI we're going to look at in maybe applying antitrust. All these risks discourage innovation, and the Chinese are laughing at it, I would think.
And is it a legitimate argument to make that you don't have to worry about competition just by looking at America when you're literally competing with companies around the globe? Do the people who support this new general welfare model of antitrust, do they just dismiss foreign competitors who are selling me the same stuff at a good price too?
So I think often they dismiss some of the big government subsidized Chinese companies when they're thinking about competition in this space. And it's one thing for the FTC to open an investigation into NVIDIA, which is a company that I think was $3 a share until like 7 years ago or something like that. So it's mind-blowing that they're opening an anti-competition investigation into them. That's one thing. It's something totally different for them to go talk to European regulators about applying European law to American companies. And that's what this current FTC did. And I don't understand what that is, except a giant boon to China.
I would just end by saying I don't think we, quote unquote, beat China by acting like China. And so I think we need to really focus on what made us so dominant in the tech space and also just our economic space as a whole. And that has been allowing competition, that has been allowing innovation, and that has been protecting those types of incentives. And so I think you can go into bad policy very easily in either direction. If you start focusing too much on size, then you can get into bad FTC policy. If you focus too much on China, you can get into kind of weird national champion policies. And so I think the most important thing in this conversation is to remember what made us dominant in the first place and mirror those
Some more
policies.
questions? Yes, sir.
So you just brought up NVIDIA. So 2 years ago, we passed the Chips and Science Act trying to get more American dominance and more competitiveness in semiconductors, and now we're investigating the semiconductor company that's doing well. What does that say? So why are we investigating NVIDIA in the first place, and what does that say about this general approach to competition?
Well, I think the theory on NVIDIA is that it's gotten really big really fast, and that's set off the sensors of antitrust folks who are worried about really big things. And you hear a lot of the rhetoric around AI saying things like, we don't want to mess it up like we did the internet. And I'm always like, well, I think the internet went okay. Relatively
Could you
speaking.
explain what they mean? Seriously, I literally don't know what that sentence means. What are they trying to say when they say that?
I mean, I think what they're trying to say is social media is unpopular.
Oh, okay.
And we don't want to mess things up because of that, although social media is extremely popular if you
yeah.
look at how people spend their time.
Exactly.
And so I think that's what they're talking about. Obviously, the internet is much, much bigger than social media. The benefits from the US approach to the internet have been enormous. If we approach AI half as well as we approach the internet, I think we'd be doing great. So I'm not exactly sure what they mean, but I think that's what they're seeing. They're seeing a big company, it's come out of nowhere. They're worried that it's going to get locked in because everybody wants to buy its product right now, that somehow it's going to get locked in, even though there's extreme incentives for every single one of these big companies that are paying them billions of dollars to build their own chips, and all of them are trying to build their own chips in this space. And they're seeing that success, and they're saying that, yeah, we should probably look into that success. It seems bad.
No, I think that's right. And, the internet, there's Adam Thier, who's a policy analyst at Tom Big, wrote about permissionless innovation. The reason why all these internet firms were able to grow so rapidly is the decision was made, actually in the Clinton administration, we're not going to regulate the internet. We're not going to go ahead and be heavily regulatory. It allowed space for all of the innovation on the edges and all of these platforms to start developing. And by the way, there's some economists say trillions of dollars, trillions and trillions of benefits to consumers, net of profits, have flowed from the big platforms. There's an economist named Professor Brynjolfsson, formerly MIT, now at Stanford, who's done some studies. If we had tried to regulate the internet like the old communications industries up front, there's a good chance that a lot of those benefits would not have appeared. Certainly by not, and consumers would be much worse off.
You had a question?
Yeah, so the US is kind of unusual in that you have two separate agencies handling competition matters. You've got the DOJ Antitrust Division and you have the FTC. I think only one first world Asian country does that. No other first world countries I know of do that. Is there any pragmatic value to having this division, or is there no reason why we shouldn't just roll them into one agency with the power to investigate, prosecute, and so on?
Well, the one argument that you saw out there was that, well, consumer protection and competition, sometimes privacy rules can affect the competition. It's a core aspect of competition. Sometimes, and it would be good to harmonize these things. That's the argument in favor of it. But really, historically, the FTC had not really tried to do that, and it's more a historical accident. There is a strong argument, I think, that the FTC's antitrust power should be centered in the Justice Department and have one central agency, and maybe the FTC retains consumer protection powers and takes the consumer protection power from Consumer Financial Protection Board, which is sort of totally free from presidential or executive control, And indeed, the FTC opposed that board's creation. So yeah, I think in theory, you could do maybe a better job of trying to melt these considerations, but that's for sort of White House policymakers. But I think the reality is, because different congressional committees control those two different areas, it had always been thought that you were stuck with the FTC structure as it is. But maybe that won't be true in the future.
Can I add one sort of pragmatic consideration in that, is that having worked a lot on the consumer protection side of the FTC, there certainly wouldn't be nearly as many economists in the building if the antitrust practice was not there. And that antitrust sense, both at the staff level but also at the commission level, that familiarity with economics is actually a very useful constraint on the wildest versions of consumer protection that the FTC might engage in otherwise.
So then I want to wrap up with a question, and I'm kind of paraphrasing several different versions of this, and these are my words only. I want to get it on the record as just a dumb journalist asking a question. Is Lina Khan dumb? Like, I don't understand. When I talk to people about the idea that, oh, well, you're getting great prices, but that's not good enough. We need to do something other than you getting a great deal on what you want to buy. I literally have normal people say, you must be not understanding the story, Michael, because it can't be the case that the top person in charge of trade wants me to have to trade at a higher price for the same good. That can't be right. So how do you explain what the current mission is without using derogatory terms? Or feel free. I'm really just
Go ahead.
I will say I don't think she's dumb. I think she has a fundamental, Yale rejected me and they let her in, so I don't know what that says. But I think there's just a fundamental difference of perspective of what she wants antitrust to do. And I think she sees society, and maybe it's a little bit of rose-colored glasses of the quintessential Main Street and the small businesses and how everyone was kind of middle class and you had the industrial like manufacturing jobs, and she wants to use antitrust as a way to kind of recreate that. I personally think that's candle makers fighting about the light bulb. I don't think that's where we are right now. I think by other metrics we are improving. Maybe we're bowling alone. I think we can fix that a little bit. We're not TikToking alone or whatever. And so I think that there's just a fundamental difference of opinion of what she's trying to create with it. I would argue that what she's trying to create isn't really feasible, and she's going around it about it badly.
Casual consumers understand supply and demand. Like, they look at the housing issue right now and they go, well, we need to build some more houses. It's not, and yet it seems is that there's another theory besides supply and demand. I mean, is that what's going on in the FTC now?
I think sometimes people get very, very smart, and then they think they can outthink basic economics.
Outthink the market?
Yeah.
High IQ, and I won't comment on personally anyone, but this is a gentleman, is not the same as wisdom. Look at all of these brilliant whiz kid people who worked for Robert McNamara and led us into Vietnam. Other people with all the top degrees from top universities made countless mistakes. You can think of them as in administrations over the last few decades. So again, that's my only thought.
And I don't think she's dumb at all. I just think she doesn't share the average consumer's values. The average consumer wants lower prices, and Lina Khan says lower prices are nice, but I'd rather have a more even society.
Well, what's nice is having you participate in this event, and having all of you show up, and for those of the folks who are down the line of the stream as well. And once again, a round of applause for our panelists here. And for ACI. And ACI, thank you very much for making this possible. The video of this will be at the InsideSources YouTube page and at the ACI YouTube page, and available as well. So share it far and wide. And thank you very much for being part of this productive conversation. I'm Michael Graham with InsideSources.